Okay, so hi, welcome everybody today. I'm back for my third video. My name is Jennifer Hamey. I'm an attorney in Ellenton, Florida, and I've been doing a series of videos started last week of what I call Hamey's Helpful Hints. There are different legal issues. People have been sending me over topics that they're interested in, and I have been trying to research those topics and then do videos on each of those topics so that I can give some legal information to people that are asking questions. So if you are new to joining me, then welcome. If you have been watching the other videos that I've been doing, then welcome back. So far I have done videos on Medicaid assets, Medicaid planning. I did one on constitutional issues and the COVID virus that's going on right now. And today I'm going to be doing estate planning. So I'm going to do my estate planning in two sections, two parts, because there's a lot to estate planning, and I know this is a hot topic a lot of people have been asking about. So I want to make sure that I give as much information as I can. Also, I just came about a seminar that I'm going to be listening to regarding trusts. I hope to listen to that today or tomorrow so that I can incorporate that into my part two, which is going to be more over trust planning and the benefits and whatnot of trusts. So today I'm going to focus on more generalized estate planning information, and then if you come back for part two, I'll give some more specific information regarding trusts and avoiding probate and those types of things. So I'm in a sweatshirt today because I'm absolutely freezing. I was able to get out this morning and get a quick walk in, which was nice. It was nice to get out into the fresh air for a little bit before the rain thunderstorm hit. But if you're here in Florida, then you know that we really needed the rain, so it was good to have. So, all right, so estate planning. What is estate planning? That's a really broad term. So when you think of estate planning, people have all different definitions of what they think estate planning is. So estate planning is going to cover a lot of different things. It's going to cover wills, last will and testaments. It's going to cover power of attorneys. It's going to cover living wills. It's going to cover trusts. It's going to there's all sorts of different kinds of trust: irrevocable trust, revocable trusts, special needs trusts. There's all sorts of different trusts you can do. So it's going to encompass all of that. Really is the broad umbrella of what we call estate planning. So when somebody comes to me and says, hey, I need to do my estate planning, and I say, oh, are you looking for a will? And they say, no, estate planning. That is what estate planning is. It's just a lot of things that fall under that umbrella. So then people will come to me and say, well, what do I need? I don't really have anything. I don't have anything. Do I even really need to create anything? Everybody has something. Everybody has a bank account, personal property, a car, some type of assets. Everybody out there has some kind of assets. So what I tell people for the most part is that there are 4 documents that I think every person on the planet should have. And that's going to be your last will and testament, your healthcare power of attorney, your durable power of attorney, and your living will. So those are 4 documents that are going to help everybody that's on the planet, basically. So I'm going to go through each of those one by one and just kind of give you a general description of what those things are. So the first 3 documents, the general power of attorney, the healthcare power of attorney, and the living will, all 3 of those documents apply while you're alive during the course of your lifetime. So they go into effect while you're still living and they end when you pass away. So a durable power of attorney is going to look at things like finances. It's going to look at naming somebody that if you are unable to take care of your own finances, sign your own name to documents such as real estate documents, taxes, creating documents on your behalf for your financial well-being. If you are unable to do that during the course of your lifetime for whatever reason, who do you want to be able to make those decisions for you? Now, with married couples, oftentimes it is the surviving spouse. And so oftentimes in those documents, the surviving spouse will be named first, and then they'll name a child or somebody that they trust as the secondary person, the alternate, if that spouse is not available. So a lot of people will also say, well, we're already on our bank accounts together. We're already on these things jointly. So do I really need a durable power of attorney for my surviving spouse to be able to do anything, or for my spouse to be able to do anything, because we're already joined on all of these accounts? So the answer to that question is still yes, because there are things above and beyond just bank accounts that the person may need to access if you are in a situation where you're unable to access it for yourself. So that's why it's important to have the durable power of attorney as well, because if you're unable to take care of those things on your own, anything regarding signing a document, say for example, you guys are in the middle of a real estate transaction. Husband, wife, they're getting ready to sell their home and purchase a new home. Well, all of a sudden, wife ends up in the hospital, is now unable to sign her name for whatever reason. She's unconscious or she's not competent. If that durable power of attorney was in place, then the named surviving spouse would still be able to sign on her behalf so that that could continue to move forward as what they originally planned. If there was no durable power of attorney and that person couldn't sign on their behalf, then that's going to hold up everything. So that would be an example where durable power of attorney would be effective to have. Okay, so that being the case, we're also going to be looking at healthcare power of attorneys, okay? So a healthcare power of attorney is a completely separate document, and this has to do with what it says, healthcare. So healthcare documents are going to look at if I am unable to make my own healthcare decisions for me, who do I want to make those healthcare decisions for me on my behalf? Now, again, a lot of times surviving spouses will name each other, but a lot of times surviving spouses, or I'm sorry, a lot of times people are under the impression that a spouse just automatically has that right. Well, if I go into a hospital, then the doctor will just automatically talk to my surviving spouse, and then they can make the decisions for me, and I don't need to have a power of attorney, a healthcare power of attorney. Again, that is not true. The doctors want to see that healthcare power of attorney. They want to know who you have allocated to make those decisions for you in the event that you're unable to make those decisions for yourself. Now, obviously, if the healthcare provider can speak with you because you are competent and you're awake and you're able to make your own healthcare decisions, they're going to speak to you about it. But if it's a situation where you are unconscious or you are not competent, you're under anesthetic for in the middle of a surgery and the doctor needs to talk to somebody about, hey, this complication came up or this additional thing came up, do we want to be doing X, Y, and Z? They need to know who they're supposed to speak to do that. Now, the third document is the living will. Now, living will is a choice by choice basis, and I have some clients where husband wants one, wife does not want one, or vice versa. So it is really personal decision up to each individual person on whether they want to have a living will or not. And a living will basically just says that you don't want to be kept on life support. If you've gotten to a place under certain conditions, in Florida, it is conditions regarding terminal condition, end of stage life condition, a permanent vegetative state such as a coma, you don't want to be kept on life support, and you are letting the doctors know and letting your significant others know, hey, don't keep me alive in that particular circumstance. They're going to do what they can to keep you out of pain, but they're not going to do anything to sustain your life. Now, here's a difference between Florida and Ohio, and I'll give you both because I know I have audiences listening from both places. So in Florida, a DNR, because I get a lot of questions about a DNR, do not resuscitate. A do not resuscitate is a completely separate document in Florida. So if you want a DNR along with your living will, then in Florida you have to go to your physician and your physician signs it. It's a completely separate document that your physician signs saying that you do not want to be resuscitated. And then the physician will sign it, and it comes on like an 8x11 piece of paper, and you can put a portion of it on your fridge. You can put a portion of it in your wallet so that you'll have that with you. In Ohio, the DNR is part of the living will. It's a completed document with both of them, and you can initial accordingly on whether you want the DNR or you don't want the DNR. So there's some difference between the states on how those are handled, the living will and the DNR are handled. But like I said, all three of those documents are applicable during your lifetime. So while you're alive, they are in effect. They're completely revocable as long as you are competent to revoke the document. If one day you wake up and say, hey, I don't want to have this anymore, you can just send it in writing to the person that you've named as your agent or power of attorney agent and say, hey, I'm revoking your powers. I don't want you to have them anymore. Upon your death, those powers are automatically revoked because those documents are only good during the course of your lifetime. So those are three documents, like I said, that everybody should have because everybody at some point in time could get sick or have that situation happen, and you want to have those documents into play. The final document is the last will and testament. Again, that goes back to, do I have enough to bother putting together a last will and testament? A last will and testament is basically this. Last will and testament says, this is who I am, this is where I live, this is who my spouse and my children are, and these are where I want my things to go, and this is who I want to make sure gets those things to where I want them to go. So even if you just have personal property or you have a bank account or you have a car, it's still important to let the court know and to let the public know through your preparation of your last will and testament that you want these documents to be taken care of or you want your assets to be taken care of by these people, and this is where you want your things to go. If you don't name something to that effect, then the court is going to have no choice but to go through what the law says as to what the court thinks that your intent would have been for your assets to go places. Now, it may be that the way that the law is set up is exactly how you wanted your stuff to go. You passed away, you didn't have a will, you wanted it to go to your spouse, you wanted it to go to your children. That's how you want it to go. But there's a lot of situations, especially here in Florida, of people that are in their second marriages, marriage later in life, husband and wife have children from separate partners that were prior to the marriage, and they have concerns about where their property goes upon their death. They don't want it all to go to their surviving spouse. They want some of it to go to the children from a previous relationship. So the will is going to make sure that it sets up so that those things go where you want it to go. So those are 4 important documents that, like I said, every person on the planet should have. And that's what I call simplified estate planning. 4 basic documents that are pretty much not going to go any further than what I've advised here, but that are going to take care of your basic needs. Okay. And I'm going to put a disclaimer out here, not disclaimer, but kind of a pet peeve that I have. Please, 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 please do not contact any attorneys, including myself, with forms that you got on LegalZoom or one of those other type of places asking us to review it. Okay, it's a big pet peeve of mine. It's insulting to me as an attorney that you would go elsewhere to get those documents and then expect an attorney to review those for you. So it would be equivalent to basically going out and getting all your plumbing stuff for the plumber that you needed and getting it all done and then calling the plumber and saying, hey, can you come over and make sure I did a good job? So, we work really hard as attorneys to go through school and to learn the education that we learn and to keep up with our craft. And so it's a liability issue, and we didn't prepare those document type deal, that we don't want to review those documents when it's not something that we prepared, and that it's not state specific, and it's not something that is something that we went through. So that's just my soapbox. I'll get off of it now, but that's just a pet peeve that I have because I'll get calls on that. And honestly, the cost for doing these simplified estate planning documents, such as the durable power of attorneys, the healthcare, the wills, they're not terribly expensive. At least I can speak for myself and what I charge. It's not terribly expensive for me to prepare those documents for you. And you're getting an actual attorney that's handling it, and you're getting my knowledge and my expertise. It's not just about paying for the documents that I'm preparing for you. It's also me sitting down with my knowledge to determine what's in your best interest for what you need, providing the witnesses, providing the notary, getting you the copies you need. It's a whole process that we assist you with. So that's just kind of my sidebar on that one. I digress a little bit. So okay, so the next topic that I'm going to talk about, I get this question a lot, especially down here in Florida, not so much in Ohio, but in Florida. I've moved down to Florida from state X, Y, or Z, and I had estate planning documents that were done in state X, Y, and Z, and are they still valid here in Florida? The answer to that question is yes and no. It's not a really simple answer to give out because it really just depends. I have seen, since I've been down here, people who have come to me and said, hey, I had my durable power of attorney, or I had my healthcare power of attorney, and it was done in Georgia. And when I went to the doctors or I went to my bank, they wouldn't take it because it wasn't here from Florida. So they do have that right to do that if they say it doesn't adhere to what their requirements are. And each state does have differences in what they put in their documentation. A lot of states will document in their will or in their healthcare power of attorneys or their living wills or their durable power of attorneys specific codes that are specific to the statutes of that state. So when you go and they're referencing those codes or they're referencing those statutes, they're not specific to Florida. Some people, especially when it comes to the durable power of attorneys that have to do with finances, they're going to err on the side of more conservativeness and say, yeah, no, we're not going to take those documents. We want to see something from Florida. So that may be a reason that you want to update those. Also, as it relates to timing, if you had these documents done in a different state and it was 15 years ago, may just be time to update them just because of the longevity since you last had it done. So those are things you want to take into place. So I can't say no, they're not valid here because they can be. I've just seen it kind of be on a case-by-case basis with some people who have come and said that things were denied. Now, as it has to do with your last will and testament from a different state, Florida will honor documents, wills that were done from another state, if they were properly done in the state that they were done in based on the provisions that that state required. So, for example, in Ohio, when you do a will, Ohio does not have a notary requirement for their will. However, they do have a two witness requirement. So when you sign your will in Ohio, you have to sign the document and two people will witness the document that you signed it. In Florida, the requirement is going to be two witnesses plus a signature. And then Florida has what they call a self-proving affidavit clause that they want added. Now, it's not required, but every estate planning attorney that you go to that knows what they're doing should be including that self-proving affidavit, because if you don't have that, then Florida says, okay, well, you don't have that self-proving affidavit in there that was notarized and signed by you saying it's self-proving. So all we have are these two witness signatures. We need you to go back to those witnesses and find them, which if you prepared your document 10 years ago could be time consuming, or not able to find those people. They've passed away, they've moved on, whatever the case may be. But they want you to go find one of those people and have them sign an oath that they have to go down to the court to sign, saying, yes, we witnessed this person sign this. Or alternatively, they have you go to a person that knows you or knew the person that passed away and say, oh yeah, this is what that person wanted in their will, and they sign an oath. So there's extra steps that have to take place if you don't have the proper documentation. And again, each state is different in what they require. So you may have some states that also have self-proving affidavits that Florida's going to be saying, great, we'll accept. Going to say, okay, we'll accept that will as valid because it honored what Ohio required, but we're going to make you go through these extra steps to get it approved here in Florida. So again, it depends kind of question that you want to look at as to whether you want to bother updating those documents or not. 9 times out of 10, I will explain that to clients and they'll say, okay, just go ahead and update the document because we don't want to worry about those things moving forward. Okay. So that's a question that I get a lot of. Let's see here. So who can serve as your personal representative? In a lot of states, they call it an executor. Here in Florida, they call it a personal representative. That's the person that's going to serve in getting done what you're asking to get done through your will. So if you say, hey, I want my Johnny to have the house and I want my Jenny to have the $300,000 that's in my bank account, I'm going to name Pete, my brother, as the personal representative, and I want Pete to make sure that son gets the house, daughter gets the money. Okay, great. So what should I do for personal representative? Now in Florida, again, very specific. Ohio, not so specific with some of the requirements that they have in serving as a executor up there. You basically just have to be over 18, be mentally competent to serve as a executor up there. Here in Florida, they not only have the 18 and over and the mental competency, but they also have the requirement that the person that's serving has no felony conviction. And now that's important because some people, I've had clients who they say, well, I only have one child. I want that child to get everything. I just want that child to serve as a personal representative. And they have a felony conviction. Florida's going to say, no, we don't care that they're the sole heir. They have a felony conviction. They're not going to be permitted to serve, and you're going to have to name somebody else or go through some other avenue that doesn't involve probate, which I'll go over tomorrow in our next segment, that will help avoid that. They also have a requirement here in Florida that the person either be a blood relative if they're living out of the state of Florida, or that they live in the state of Florida. So if you are from, and I actually have this issue going on right now, client was from Ohio, said, hey, I wanted my attorney from Ohio to serve as the executor, had the documentation done, and had passed away. And that attorney can't serve. I can't do anything with that. I'm handling the probate. There's nothing I can do with that because the court says, okay, this attorney is not a resident of Florida and not a family member, not a blood relative. So they are not permitted to serve. So those are things you got to be careful of. Again, make sure that you get an estate planning attorney that knows all these little nuances because they're very important. Florida is very specific with a lot of their requirements. And again, each state's going to be different. So even if you're listening to me from another state outside of Ohio or Florida where I don't practice, make sure you get with an estate planning attorney that knows what the nuances are for the state, what the requirements are for these types of things, because they're going to be important. Another important part in Florida is the homestead. The homestead provisions here in Florida are very, very user-friendly, if you will. They are very much about protecting people's homes, protecting them from creditors, protecting them down the generations as they continue to go on. But with that being said, there are requirements that have to be put into place in the wills regarding homes. If you leave your home to, and I've run into this situation, I want to leave my home to a third to my sister, a third to my niece, and a third to my neighbor next door because she took really good care of me. Well, what's going to happen is the third to the niece and a third to the sister are going to go directly to them because they're blood relatives, but that third that you left to the neighbor is not. And it's going to be subject to creditors. So if you had creditor issues, that third that you left to that neighbor is going to be subject to the probate, and it's going to be subject to creditors possibly taking that amount. So you want to be really careful again about who you name for your homestead, name for your property, your homesteaded property here in Florida, who you're naming to get those things, because it really could play into a part of if some of that asset may be liquidated in order to pay back creditors because it's not protected. It's no longer protected. Again, you got to watch with the language that gets put in there. So again, it boils down to having an attorney that really understands the probate, really understands the requirements of the laws of the state that you're in to make sure that those assets are being protected the way that you want them to be protected in the best way that they can be protected. Okay, let me see here. Okay, so I think for today I'm going to wrap that up with just the general information for the estate planning, just to kind of give you some broad strokes of what's happening there. Like I said, tomorrow I'm going to dive into some more detailed things regarding trusts. How do I avoid probate? What are some of the other things that I can do to set up my assets to avoid it having to go through the probate process, to get it to the places I want it to go as quickly as possible. So we're going to discuss those tomorrow. Like I said, I try to make this a two-part because I don't want it to go on and on. There's a lot that can be said, and there's a lot that can make it time-consuming to go through, and I don't want to get people bored where they're like, oh my God, she's going on forever. So I'm going to cut it off there. As always, like I've mentioned in my other videos, if you have any questions, any additional topics, any follow-up you want me to give you from the videos I've shown so far, feel free to message me, send me an email. My email is jenniferhamey@gmail.com. My law firm is Jennifer L. Hamey, PA. Like I said, it's in Ellington. I have a website, jenniferhameypa.com, that will give you a lot of information on the website as well. And you can send me a message through there if that's the easiest way. I have been able to download these on YouTube as well, these videos. So if you don't have a Facebook page and you're hearing about me from some other source, then you're welcome to look at the YouTube videos as well. And that will show you the videos that you may be missing if you don't have a Facebook page. So I hope everybody has a great day. I will be back, like I said, tomorrow with part 2. Stay warm, stay safe, and we'll talk soon. Thanks. Bye.